this Thursday morning, April 3rd, and we are taking some additional testimony on S-109, the miscellaneous judiciary bill, and then we will turn to S-45. But we will start with Willa. We're just gathering folks who have any kind of pieces of the puzzle that is our miscellaneous judiciary bill, and having folks comment on those components. And I have your name on a couple of the sections at least, but you're welcome to testify on anything, Willa. So over to you if you identify yourself for the record and proceed.
Good morning, Willa Farrell, Attorney General's Office, Court Diversion and Pretrial Services. Thank you for the invitation. There are a few points, as you say, Chair Lalonde, that I noted and actually had spoken with Eric Fitzpatrick about. So jumping right in on page 1, line 14, this is a proposed change to the adult diversion statute that was changed last year in Act 180 and relates to the pre-charge component. So there's, well, it relates to pre and post charge. So there is this phrase harmed party, which is a term used often in restorative justice processes, responsible party, but that's not defined in statute and it's not clear. So we're suggesting just that the phrase be person referred to the program. So it's very explicit who we are speaking.
Sounds good. Any questions on that one, folks? I don't see any questions.
And then jumping to page 13. This also is a proposal that relates to Act 180 from last year. It is in the Title 33, which is relating to the risk and needs screening for youth. So there is a provision you'll see on page 13 and the proposed changes on line 10. So a state's attorney may refer a youth directly to a program approved by the department. And when reading Act 180 and the context of pre-charge diversion, we thought it would be good to be explicit that that's an option, sort of to tie back this statute to the diversion statute. So that's just adding the phrase pre-charge diversion pursuant to Title 3, Section 163.
Great. Makes sense, and thanks for catching that. Any questions on that? All right. Excellent.
So those are the
Those are the only ones that we had your name by, I believe. And all right. Well, I really appreciate that. And thank you for being available this morning to weigh in. Any parting questions? No, we're all set. Thank you so much.
Okay. Great. Thank you very much.
Thank you. All right. And next we'll go to Jennifer Pullman. Good morning.
Good morning. I had hoped to be with you all today, but just got my pup home from the ICU after 2 weeks, so I can no longer afford gas to travel anywhere. Yep,
I know the feeling.
Yes, those of you in Chittenden County are probably familiar with Bev's and what happened. So, but
yes.
He's home. He's home. So good morning. For the record, my name is Jennifer Pullman. I am the Executive Director of the Vermont Center for Crime Victim Services, and I appreciate the time today to speak on the miscellaneous judiciary bill. Specifically, today I will confine my remarks just to Section 10, which on my version is on page 6, and that refers to the Victims' Compensation Program. I did ask Nate to post 2 documents on the committee page that both I see that are there that both explain an additional amendment that we have to our original one, as well as provides the entire statute with respect to 5351, because that definitional section is really important, and I'm going to explain why it's important to have that entire context. We had put this proposal forward before this budget session. As you all probably recall, we had testified that the compensation fund is looking at a projected deficit of $562,000. And currently we are still struggling to receive some sort of support for that. But so I don't think that's not the reason for this per se, but it's more underscores what the concern is. And to put it, so you'll see the language currently is that is confined to our intervener definition, which is quite broad and is broader than other states, and does allow for a claim to be considered eligible if somebody intervenes and suffers an injury. And it's important then to look at the entire statute, because subsection 4 defines injury for purposes of our compensation program can just be emotional injury. So what has happened recently, and it's only a couple of cases, but we're concerned about trends, is that people who have called 911 have filed a claim and said, well, based on your statute, I'm eligible. And I'm sure that they did suffer. I'm not going to, minimize what it would feel like to be in that situation. But when you think about a $10,000 claim, somebody being eligible, especially in this day and age where everyone has a cell phone, and I'm thinking most recently about the case of the Red Square homicide, that could potentially really bankrupt our fund even further and put undue stress on the 3 people that we have that do this process in our state, that do the verification investigation to figure out, who really intervened. For example, if 10 people call 911. So for us, it felt more true to what we imagined the intent was for a regular intervener, and I'll qualify why I said regular, to be only eligible for a compensation claim if they have experienced physical injury. What we looked at further in looking at the definition, and hence the proposal before you, is that we have the antiquated piece in the subsequent clause that also says or police. And I can't remember any place in our laws anymore where we just say police. But we started thinking about again, what our understanding of what the intent would have been or might have been, and also the first responders that we want to cover. So our proposal would be to, as you see, add in the language physical for your regular intervener, but then cross-reference what's in current law and bring in protected professional instead of police. So that would grab in your EMT workers, healthcare professionals, firefighters, and again, allow us to basically provide the same coverage that we could and do under intervener statute, but really name those as the folks that we want to acknowledge, are truly, again, the intervener. We had a case wherein a EMT provided CPR to an individual who was, essentially covered in blood, and they had physical contact with that blood. All they sought was coverage for testing to make sure they had not been exposed to any diseases. We would want to, of course, be sure that we could cover those situations. So we believe the proposal before you would allow for us to not have to cover the 911 calls from the average observer, but also be able to provide broader support for the first responders.
And I see that protected person is defined in 13 VSA 1028.
Yes, you set up established a crime not that long ago, actually, but that's within current criminal code.
Okay.
And I'm certainly not. I'm sorry.
No, go ahead. It's just that for folks, it's protected professional shall mean a law enforcement officer, a firefighter, a healthcare worker, an employee, contractor, or grantee of the Department of Children's and Families, or any emergency medical personnel as defined in 24 VSA 2651. So you jump over to that one as well to continue to read profession. Okay, all right, great. Yeah. Questions for Jen, or did you have more? Oh, I'm sorry.
No, let her go ahead if she's got more.
No, I don't. I just wanted to apologize for my clumsy attempt at pretending to be Attorney Fitzpatrick, but I'm sure that he'll make my words make sense.
Yeah, I don't know if I don't think this is a question for Jen, and I know it's existing language, but under victim, the person who sustains injury or death as direct result of the commission or attempted commission of a crime. If I am committing a crime and sustain, the way I read that, and sustain an injury or die as the direct result of the commission of my crime or attempted commission of my crime, am I then a victim?
Those cases usually go to our board. If the person is involved in activity that contributes or causes their injury, those are not automatically eligible. So we always bring those to our board.
So not automatically eligible, how
No.
could somebody be eligible?
Well, let's say that there was a case where somebody, and we seem to have a lot of these, where it's a drug deal gone bad. And somebody shows up to somebody's house to purchase drugs. They are giving them, providing the drugs, and then in turn are leaving. They turn around, the deal is done, and they get shot in the back. That would be a case where the board would have to determine whether that level of criminal activity resulted in the level of violence that was returned. There are some that are
Okay.
more clear cut. That would be one, again, that does go to our board, but there are some that are really much more clear cut.
Right, so, okay, thank you.
Barbara?
So I'm wondering again if my question is more general or for you, Jen, but with some of the parity laws related to mental health and physical harm, I mean, we do have laws that just deal with physical harm, but we also have, and I realize this is just in terms of the response, the helpers, responders, but might there be situations where really there's incredible trauma suffered by somebody? And would the way you're proposing the language, would there ever be a way to make an exception for a really unusual situation that hopefully is too horrible to come up with an example for?
Yes, there always is that discretion, and we do utilize that infrequently, but we do when we have that case that does not fit squarely within what we're trying to cover, but everybody on the team is like, this really needs, in that case, that also goes to the board. So if we're trying to fit that square peg into a round hole, there's still that option, still that avenue.
Yeah.
This would just make it more clear that, again, we have that discretion versus it being, the plain reading of the statute would suggest that everybody that calls 911 who's a witness could file a claim.
Thank you. It's interesting. It's interesting. And
Well, these laws are very outdated and were, again, created before we all had cell phones in our pocket. And
Right.
it just changes the dynamic.
yeah. Thanks.
Any other questions for Jen yet?
Yeah, not really quick. So with your budget shortfall, I gotta believe the whole definition of discretion kind of changes with the board. Because you're not gonna have the funds to take care of as many people.
It certainly does.
That's kind of a question, I guess.
No, it does. And that's where, if it's in the statute, we're mandated to do it. And making these changes gives us a little more flexibility to be able to make those determinations. But currently, again, a plain reading would suggest that someone who calls 911 would be eligible. We don't want to, we are a leader in the country in terms of making additional coverage that we provide. I shouldn't say additional coverage, but for example, other programs require that you file within a year. Other programs close your case in 2 years. So there's other ways that we don't want to go down that road, but, and we're hoping we don't have to. So this is a very small tweak to, I guess, fend off a potential trend that we see happening.
Thank you.
All right. So thank you very much. And I do
Thank you.
understand that you have some other language that may be going through the House Corrections and Institutions, but this may also be a vehicle. And we're going to be taking up amendments probably next week. And I know that you sent me some language, and we'll take a look at that and have you back in next week on that language.
Thank you. Yes, this bill is way too short right now, so
Yes,
we all have to jump in and add to it. Thank you.
Exactly. We have several things that are going to be heading into this. So thank you very much.
Thank you. I appreciate your time.
Thank you. All right, Jim, if you could join us, and thank you very much for on short notice being able to testify. If you could identify yourself for the record and proceed to talk to us about, and I believe it's, well, you probably know the section you're talking about. I'm trying to find it right now, but oh yeah, probably section 19, if I recall right.
19, correct, yes. For the record, my name is James Knapp. I go by Jim. I am a retired attorney, and I am presently the co-chair of the Vermont Bar Association Real Property Section. And we worked with the folks, Liz Smith over at CADIC, to propose this additional corrective measure to add on to 27 VSA 348. By way of general comment, the real estate section is almost always happy to see additional corrective language in there, because if you're in the land records and you find a 25-year-old document executed under a power of attorney 25 years ago, but you can't find the power of attorney technically under the statute as it's presently written, you have to throw up your hand and say, wait a minute, somebody's got to dig up this power of attorney because that document's not valid. And so what it ends up resulting in is delays and possible problems for people who want to buy or refinance their house. So we think the language is good. We actually had a part in drafting it, and we think the concept is good. And I'm happy to answer any questions, but really Attorney Fitzpatrick and Attorney Smith did a great job of describing exactly how this is intended to work.
All right. Are there any questions? Ian?
Hi, Jim. Thank you for being here. The line 14 on page 15 of S109, there's like a carve out. This is in the section above that says this subsection shall not apply to a power of attorney obtained by fraud or forgery. And there's a 3-year look back in that subsection E. Should there be a similar carve out for this new subsection F?
I would draw a distinction between the intent of what's being corrected in subsection E, which is where that sentence from line 14 that you referenced, there, what we had was an issue that under the special powers related to the emergency administrative rules during the pandemic, the power of attorney in use at the time required that the witness and the notary be different people. And that was obviously hard in the pandemic. It was hard enough to find a notary to execute the document, especially if you were using the remote ink notary provisions, which the Secretary of State helpfully provided, but they were a little complex. And the distinction between what we're trying to correct here, the power of attorney was the immediate issue. So a power of attorney that was being executed by fraud would definitely be noticeable. Here we're talking about old powers of attorney. I suppose you could add in it would be not unreasonable to add in that the subsection doesn't cure the problem for a power of attorney obtained by fraud or forgery. That might actually be a good addition to the end of F. But yeah, now that I've talked my way all the way around in a circle, which is often what we do as lawyers. And in fact, if you wait a minute, I might be able to go around in another circle. But to answer your question, yes, adding that additional sentence to the end of the new proposed section F would be a reasonable change.
Okay, thank you. All right. So we will do that. Anything else, or any other questions for Jim? I don't see any. Thank you so very much for being available, Jim.
Absolutely. Thank you for taking the time to hear me. Thank you.
All right, excellent. Perfect timing, Chief Burke. So we can turn to you and hey, wait, different background. What's going on? I am not used to this.
Thank you, Representative Rachelson.
But so maybe sometime offline, I'd love to talk and see how it's going there in Burlington. But that's not what we're having you here today. We're having you to talk to us about I guess it's called the Public Inebriate Program. And if you could weigh in on why we should repeal this provision that we keep on sunsetting and keep on delaying, which my understanding would no longer allow DOC to house individuals for short periods of time who are inebriated. But I'll let you explain. That's probably the extent of my understanding of this. So.
Thank you. That's precisely the issue. And so for the record, my name is Sean Burke. I do serve now as the interim chief of police in the city of Burlington. I am here today representing the Vermont Association of Chiefs of Police on the miscellaneous bill. So in short, what happens under the incapacitated person statute, when a person presents to them either a risk to themselves of harm or to others due to a level of intoxication, law enforcement has the ability to take them into what we call protective custody, and then they're screened and determine where they're going to stay in order to what's referred to informally as detox or sober up. And in these instances, we used to partner in Chittenden County with the Howard Center, and they would do the screening and either refer the person to the emergency room or to the Department of Corrections if they posed a safety risk to the program. Howard has since closed that program, so the emergency room is doing all of the screening. This is a little different county to county, but essentially most of these clients are seen in an emergency room. When their behavior escalates and they're really posing a risk to emergency room staff, but it yet hasn't teetered over to a crime, that's the problem if we lose the ability to then have that client referred or that patient referred to the Department of Corrections to be safely held in a secure facility. And we know through a lot of other bills and through the lived experience on the street here, how dangerous emergency rooms have become because of the number of acute patients that are presenting there, whether they're in a mental health crisis, intoxicated, they're in police custody for a crime. And this is really a benefit to that body of employees and that function of public service in Vermont, meaning the emergency room, and keeping those places safe. And why this bill keeps getting sunsetted, or this clause gets sunsetted, is there's no other alternative for folks that are presenting as dangerous due to their intoxication. They need to be held by the Department of Corrections safely in order for us to really prevent them from harming someone, committing another crime, and then becoming involved in the criminal legal system. We avoid this on a day-to-day basis, on a regular basis, I should say, by having this option, being able to lodge at the Department of Corrections available.
Right. So, and essentially, this is repealing the provision that has continually been delayed because of what you just said. It's not changing current law. It's changing what would go into effect, I believe, this summer if we didn't get rid of this.
Yeah,
So,
and this has been kicked several times and there's been no solution. So it's time to repeal this. So we're not, in the 11th hour wondering what is going to happen.
Right. Barbara, go ahead.
It's so nice to see you, Chief Burke.
You as well.
Really great. So I'm wondering, because I've talked to a few people, constituents, and some of my human service colleagues. And I think actually I've talked to one of my committee mates about this. So the issue with the Howard Center stopping to do it was, I think, a reimbursement issue. But my understanding is that it was working pretty well when the Howard Center did it. And so I totally get that having it go to the hospital does not make sense for so many reasons. I cannot, and I know this isn't necessarily a question for you. I think it's one that I would pursue if the Howard Center and other providers like the Howard Center were working, because I'm not sure that it's going to be more cost effective for the state to have DOC do it. And so I'm just curious about that. And I realize that isn't your issue, but if there were issues with how it was being delivered and this new method will be improved, it would be helpful to hear that.
Yeah, so I don't know if it was necessarily a complete funding issue that led Howard to close Act One Bridge. There was definitely a staffing component to that as well, post-pandemic. And Act One Bridge did function well because folks that were cooperative but in need of a place to essentially sleep it off, they could stay there at Act One and never hit the emergency room. That was really a small group of the population, though. Because it was like a single staffer at the Pearl Street facility. Many folks have been historically referred to the emergency room to be screened, and then based on danger acuity, referred to corrections. So I think Act One Bridge was a loss for a lot of different reasons. I mean, people could just walk there themselves. It also addressed other substances. But Howard would have to speak to exactly why that came to an end. In other counties, it looks a lot different. Perhaps Representative Oliver will recall when I was first a police officer in Windsor County, we would literally meet a guy named Jack Pippin in a parking lot somewhere along Route 4, and he would ask the person 4 questions, give them an alka sensor, and we would take them to jail. So, I think this looks a lot of different ways. But ultimately, to keep people safe from themselves and to keep the broader community safe, we do need the DOC option.
Great. Thank you. Thank you for filling out that information.
Any other questions for Chief Burke? All right. Thank you so much for finding time in your schedule to be available. I really appreciate it, Sean, and good luck there.
Always my pleasure. Great seeing everyone this morning. Best of luck with the deliberations.
All right, thank you. Thank you. All right, so that's all we have on S109, and I'm pretty sure that O'Grady is not available to 10:30.
It's not. I'm sending an email anyway.
Yeah, so